Well, good morning and welcome back to the second floor. The third floor worked out for approximately 4 hours. So now we're back and we're just going to make do with what we got down here. I'm going to call this morning's docket. When I call your name, please say present or here so I can mark you down as where you're supposed to be. Jimmy Saul Booker. All right, thank you. Alton McCurley.
Judge Matt David on behalf of Mr. McCurley, he's out of the hallway.
Thank you, sir. Monica Roberts. Good morning. Ms. Roberts, go ahead and meet with the probation department. I think they're requesting a urinalysis before we call your case. John Robert Davis. Thank you, sir. Jerica Simpson. Jerica Simpson. Recall her case. Maybe she's in the wrong spot. And then Mr. Spencer, you've already seen Mr. Spencer. You haven't. Jay Sean Spencer. You haven't seen him yet. Dennis Stanley. Thank you. Avery Tienda. Avery.
I have not seen him this morning. I met with him earlier this week, go discovery, and he wasn't my nation.
Michael Ward. Thank you, sir. Charles Young. Thank you, Mr. Manning. Lindy Delaney. All right, I believe we have there's a warrant for Miss Delaney, so we'll go ahead and take her into custody and we can put her over here and then we'll recall her case. Landon Watson. Landon J. Watson. Matthew England. Andrea Young. Thank you, sir. Ivan Rostro Garcia. All right, and Mr. Garcia, meet with the probation department. They're wanting your analysis before we call your case. All right, is there anyone who's present who believes that they are on today's docket and your name's not been called? Or do we have anything that's agreed this morning?
We have, Ms. Scurry, he's scheduled for a polygraph examination in Dallas on 30th, and we were gonna escort the case, so that's completed with Ryan Holden. It's at 11 o'clock, I believe.
On January 30th?
It's, yes, sir, it's next week, I guess next week, 30th. We'll be turning those results over to, honestly, probation department and Mr. Curry. He's paying for it.
Okay, any objection from the state? All right, court will reset Mr. McCurley so he can take his examination. Court will reset. Are you available on February 23rd? 23rd. February.
In the morning.
Okay, all right, court resets Mr. McCurley, and he's in here, right?
He's outside.
Here, go ahead and bring him in. All right, court is resetting Mr. McCurley until February 23rd at 9 a.m. and probably just plan on being here. If we move, I'll let you know.
Yes, sir.
All right, so once you sign and get your yellow copy, you're free to go. Thank you, Mr. England. Anyone else who's agreed or ready to proceed? Mr. White, you may. Is this on Mr. Rostro?
Again, going to the state jail, so we're going to need to reset for probably, I guess, the afternoon.
Okay.
But we could use them units at a time, a couple of weeks at least, to be able to get our affairs. But we can certainly do it in February, no problem.
What about What about February 7th or 9th?
I guess the 7th probably.
So
Second is, do you have a docket on those days?
I've got the 7th and the 9th.
Okay, got
That's, yeah, that's all I got for criminal. I got civil before the week, or I got criminal trial the week before, civil trial the week after. And what's Mr. Rostro going to be taking?
6 months.
6 months. All right, I'm having him drug tested right now, so let's see how that turns out. And then, once I get a report on that, we'll bring him in, and if he's clean, we'll be good to go. If he's not, we'll talk about it.
Because I don't want to have to go back to the office and have to answer all the phone calls that I've had.
Yeah.
That's 4 days.
I bet. And Mr. White, did you say the 7th or the 9th? The 7th. Okay. Six, Matthew England. Mr. England, come on up with Mr. Schmidt. Motion to revoke today?
That's correct, Judge. The state's motion to resolve elections. The primary basis on the motion is new offerings. Mr. England was in custody for the simulation. Still waiting on the state.
He was just indicted on the new charge last week. So I don't know if we give it numbers, and I'm sure hasn't been set yet. That on Friday, but he was just indicted on brand new charge on Friday.
That explains that. It's ultimately what we want to do is try to resolve the law. I suppose once we get together, just have an action. Do a package resolution.
So you're wanting to carry the motion, you're wanting to carry the motion to revoke with the newly indicted case?
Stay with no objection.
What's the level of the new case?
It's a something certain.
Same charge that he's on now? Same 3rd-degree felony? So, 2nd-degree felony.
I don't know what this would agree with. I don't know if the court's docket is correct. They're both peace officers, so they should be theoretically indicted. The new one is a 2nd degree. Something peace officer.
And is the state alleging that that occurred while Mr. England was obviously while he's on motion to revoke? Has he had any violations while he's been on bail? Is this a motion to revoke or motion to adjudicate? Adjudicate. The docket says revoke, but I was wondering how he was on bail.
That's just my understanding, Mr. England, once you make bail, this meeting, I believe Mr. Carl down as well as probation. My regular institute, it's mean that we should stand for a while, but obviously,
And I don't believe the court has received the new indictments, and so I don't think there's any settings yet. All right, let's bring Mr. England back on February 23rd, and then we'll do a calendar adjustment on that day once we know when the indictments are in and when they're set for arraignment.
What date was that, Judge?
February 23rd. Free to go. Anyone else ready to proceed? Ready for me to just call the docket? Do we know who's going to be contested hearings today?
Judge, Mr. Booker. Case will be.
Mr. Green, will you be contested today with Ms. Roberts?
We will not be, Your Honor. We're going to withdraw motions. Said we're not.
All right, let's go. All right, let's go ahead and do that then. Ms. Roberts, if you'll come forward. CR 22-224, CR 22-225, State versus Monica Rochelle Roberts. Court finds that it set today's hearing on Ms. Roberts' motion to suppress. Mr. Green, you've indicated that Ms. Roberts is withdrawing her motion to suppress today.
That's right.
All right.
Facts, case law.
All right, record will also reflect that Ms. Roberts was UA'd by the court today and was negative. Court will grant the motion to withdraw the motion to suppress. Court will set Ms. Roberts for docket call. Are you available on February 21st? All right, court sets Ms. Roberts then at 9 a.m. on the 21st for docket call. Once she signs her notice and gets the yellow copy, she's free to go. You may.
The docket ID filed yesterday states, motion to withdraw, the motion to revoke. This gentleman is being held on our warrant in Missouri. He's already been adjudicated. It was a aggravated assault that was pled down to a misdemeanor, extraditing for that. So we're just asking to be discharged and then warrant be withdrawn. So our sheriff's office doesn't have to go to Missouri and get him over a misdemeanor.
Does he owe anything or?
I don't know, Your Honor. This case is, I think he's been absconded for 4 or 5 years at least. And he has significant health issues in their jail in Missouri. So Sheriff Carter contacted us and asked if this was something that we could dispose of.
You got to talk to probation about it.
No,
Okay.
I'm happy to do that if you would like to.
Yeah, I do. I want to know how long he's absconded and what he owes and all that good stuff before I do it.
Sure.
But I'll let you hold on to that and then you'll talk to them and they'll let me know.
Judge, that's all my business kind of do.
Yes, good to see you.
Good to see you. Man, you're gonna have to, need to get some of that paint on seal stuff that they sell on TV.
Flex seal.
Yeah, that's it.
You know what? You're the first person that's thought about that. I need to get a lot of flex seal.
To put it
Sponsorship.
We need to get a hold.
put it on a boat, it's got a hole that big in it and float across the ocean.
Hey, we put flex seal on here. The next rain it comes, we may float away.
That's right.
Good to see you.
Yeah, unless you want to know if you could take her, I already need to talk to her.
Oh, no, I have to call her. Oh, the attorney wants to talk to her?
No, I want to know if he could take her.
Oh,
now
well,
for
I
me.
haven't called her case yet,
Okay.
so I just put her in custody so she didn't flee.
Yeah.
So I need to call her case with Mr. Murray later, so. Morning, Mr. Harden, are you ready? All right, your client in here.
John Robert Davis.
All right, John Robert Davis, motion to adjudicate.
This is my first appearance. I haven't received anything. I just talked to the district attorney.
Here, mate, I can't hear you, so. If you'll go right there and make that announcement, so they can hear. All right, go ahead. This is John Robert Davis, motion to adjudicate. Go ahead, Mr. Harden.
This is my first appearance of this case. I haven't reviewed the evidence yet. I don't get to review it that time I'll be able to check it out. Fine, and you can bring it up and say,
We're working on getting that into the case, so we can send them all the online portal information. It is a motion to adjudicate, so. We would be unopposed to resetting the next docket. If we could reach an agreement before, we will notify the court. If not, we'll be ready in February.
All right, Mr. Davis, court's going to reset your case to February 23rd. You have any scheduled conflicts that day, Mr. Harden?
okay, that would be fine.
All right, that'll be in the morning, Mr. Davis. Once you're still on probation, you still got to report, follow all your conditions. And once you sign the notice of appearance and get the yellow copy, you're free to go. Oh, yeah, do I have that? All right, Ms. Heisel, who else was contested? So I had Mr. Booker. Who else do you,
We're gonna have a short hearing in
Young?
I believe we're probably just gonna submit the video, based on a minute, and ask you to take it under.
Okay.
Take extremely long, for scheduling purposes.
Okay.
The public of those young to be accepted, Mr. Mayor, leader and I would still request to speak with you about Ms. Blaney's case in chambers. At some point.
You said on Young, it was Andrea Young, not Charles Young, right? Andrea.
Yes,
And let's see. Mr. Manning, you ready on anyone?
Should we have one, Mr. Young, Charles Young?
All right, Charles Brandon Young, CR 22-345. 346. Sure, we're set for pretrial today?
That's correct, Judge. We have, Mr. Young is a long haul trucker, and so him getting into my office is a little more difficult. We've arranged an opportunity to speak about discovery via Zoom. Additionally, we received an offer from the state this week, but it's incomplete. We're still waiting on a number of restitutions. We didn't request additional pretrial. I think we might be able to get this case resolved. It's just we need to have all the information.
Are you available on March 9th?
I believe so, Judge, yes.
Okay. All right, court will set Mr. Young for an additional pretrial on March 9th. That'll be at 9 a.m. And just plan on being here, Mr. Young. I'm not sure. We may be in a different courtroom, but just plan on being here at the courthouse, okay? All right. And so, hey, also, Mr. Young, I need you to report to the pretrial release officers. Have you signed your pretrial release papers? Okay, all right. I wanted to make sure. Once you see him, then he'll get you squared away and you're free to go. What about Landon Watson?
Judge, I heard nothing from his attorney.
And Mr. Platten's here. He's outside. Yeah, he told me he had a Zoom with Wood County at 9, so I told him he could take care of that and then step in. I just didn't know if y'all knew it was gonna be contested or not.
I don't believe so, but I don't think, I know he's here. I don't know if it's contested because Mr. Platt, I'm not, yeah, Mr. Platt hasn't reached out, so I'm not aware. I don't know when Mr. Platt was hired. Maybe it's hired in the month. We haven't spoken. I don't know that he has stuff all that.
All right. All right, Ms. Heisel and Mr. Murleader, if y'all want to meet right back here. Stand in recess for just a moment. All right, Ms. Delaney. All right, this is cause number CR 2399, CR 21150. State versus Lindy, is it Sherry or Cherry? Sherry Delaney. Ms. Delaney, if you'll raise your right hand, I'm going to place you under oath. Ma'am, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? All right, you can lower your hand, Ms. Delaney. Ms. Delaney, I have two documents in my hand that both appear to have your signature. They're called waiver of jury trial and two separate cases. Did you go over these forms with your attorney, Mr. Murleader? You understand that you have the right to have your case tried before a jury of your peers. And you understand that no one can take that right away from you. However, you can waive that right. You understand? You got to say out loud so my court reporter can take it down. You understand that you can waive that right. And by waiving that right, you're waiving the right to confront the state's witnesses and cross-examine their witnesses and evidence in front of a jury. You understand that? Right. And once you waive your right to a jury trial, that right may not be restored to you. Do you understand that as well? And has anyone threatened you, forced you, made you feel like you had to waive your right to a jury trial in these cases? Yeah. And you're wanting to waive your right to a jury trial so that you can enter into a plea agreement with the state of Texas. Is that correct? And it's my understanding that you want to enter into a plea agreement at a later date wherein you would be convicted of these offenses, or at least manufacture delivery of a controlled substance and go on probation for 10 years. Is that correct? Yeah. All right. And Mr. Murleader, you've explained to Ms. Delaney the consequences of her waiver of right to a jury trial.
Yes, Your Honor.
And do you believe that she's entering into this waiver intentionally, knowingly, and voluntarily?
Yes.
All right. All right. The court will find that Ms. Delaney has been admonished as to her right to waiver of jury trial, and that she is waiving her right today voluntarily, intentionally, and knowingly. And the court will approve the waiver of jury trial. And we will set Ms. Delaney for plea on March 9th, and that'll be at 9 a.m. I would just plan on being here at this courtroom. So understand that you're going to be taken into custody today, and you've got a warrant out of Smith County. And if you're still in jail over at that time, we'll be able to confirm it. If not, you need to be here on March 9th at 9 o'clock. Okay. All right. Anything further, Mr. Murleader?
No, Your Honor.
All right. Thank you, sir. Right. Mr. Booker, if you'll come on up and have a seat, we'll get started on your case. I don't see any, we have any other attorneys that are ready? How long is your case going to take? Did you say just going to be a? All right, hang on, Mr. Booker. I'm going to go ahead and let Mr. Thorson come up. I think his is going to be shorter than yours. I anticipate yours is going to be a little bit longer, so. All right, this is cause number CR 22-121, State versus Andrea Nicole Young. And I show that we're set for contested hearing today. What will we be contesting today, Mr. Thorson?
Your Honor, this is a motion to suppress filed by the defendant regarding basically the totality of the case. And our argument is the unreasonable amount of time of detention before there was any basis to arrest my client. This is a case involving possession, an allegation of possession of marijuana in a facility, and obviously that search is incident to the arrest. Detention leads to arrest, leads to searching.
Thank you, sir. All right, and it's your motion.
Judge, we've agreed, we would agree to the thrust of the defense's motion that the original detention was not subject to a warrant, And then state would concede distant into the arrest, about an hour into the arrest. The officer basically states that he is going to write her a ticket and then release her. The return comes back and she is wanted or pardons a parole warrant, and at that point gets arrested, then taken to jail. The state and the defense agree, as long as Mr. Thornton doesn't disagree at this point, that basically we're just going to submit the body cam video under stipulation purposes of this hearing only, because it is about an hour long. Take that long out of your day today. Ask you to review that, basically take that as the sum of the evidence in this case, make some brief argument to the court, and then await your ruling in the near future.
Okay.
Your Honor, we agree with the state's position on that. I think the facts are the facts, and because the body cams are all on video. So basically purely we agree on the facts, and I think that is the easiest way to submit them to you. The video, the body cam trips off after about 50 minutes. So there is a 50-minute
It's
video.
broken into 7 sections.
There's a 50-minute video, and then there's a second, like 30-minute video, but really the submission of the facts go from about 9:09 a.m. until about 10:17 a.m. So we would agree with that. I think that's the easiest way to submit it to you, so we're not sitting there watching the video for an hour plus. And then I just have some brief factual argument to point out to you, and then thanks.
So this time, the state would offer State's Exhibit 1 for the purposes of this hearing only, under stipulation from defense, as to this motion in and of itself.
Correct.
All right, then court will admit State's Exhibit 1 for the motion, for the purposes of the motion to suppress. And who wants to argue first?
This is of course a motion. I believe you would have first bite at the apple.
Thank you. Effectively, when you're reviewing this video, this encounter begins as a call to effectively address a community caretaking situation, an allegation of somebody sleeping in the parking lot of Dollar General van. The van PD responds, it's an officer McKee who was with them at the time, somewhere else now. They arrive on the scene at 9:09 a.m. Encounter my client. They effectively wake her up, encounter her outside of the vehicle. He calls for a warrant check at 9:16 a.m. And shortly, immediately thereafter, he asks to hold the return for whatever reason he did. And I believe, based on the circumstances, I'm going to assume that he was setting forth an investigation regarding one of the state case. He calls a trooper at about 9:17 a.m. And calls a trooper from somewhere else in the county to come to the Dollar General. He tells the trooper on the call, if you can't make it effectively, we'll figure out another way to handle it. The trooper, they search her car, they find what they believe to be a marijuana roach, and then at 9:29, trooper's still not there. He changes his opinion and said, well, it's just a broken cigarette, it's not marijuana. Continues to say that, you know, he smells marijuana, pretty exhaustively searches the vehicle. My client is cooperative with that. She tells him how to get in the trunk at 9:30 a.m. There's some issue with the electronics in her car, and she told him how to get in the trunk. They search really exhaustively, don't find any controlled substances. Trooper arrives at 9:35 a.m. He has a lengthy discussion with her that's within view of the first body cam. And he continues to discuss with her. They at 9:47, they're still having a discussion that they smell marijuana, but they haven't found any marijuana. Eventually, the trooper off to the side conducts some field sobriety tests. And the officer calls for a return at 9:53, but for some reason, I think it's just a return on the car, that 10 code or whatever they do. And the car call comes back clean. They then do field sobriety tests on her, and the trooper renders his opinion to the officers at 10:07 that she's not intoxicated. But caution, she has family on the scene by that time. Cautions that she shouldn't drive and she can go with family. They Then I guess tell her that they're going to issue a ticket for drug paraphernalia and cut her loose. And that is about 10 AM, so we're like an hour into this encounter. He goes to write her the ticket in his vehicle. Has told her he's going to let her go, and then I think either she's on the computer, you can't hear a radio return, but figures out she has a parole warrant and encounters her, hooks her up on a parole warrant, and they go on to jail from there, and search later ensues that leads to the allegation of possession of controlled substances in a facility. So that is effectively trying to give you some marks to look at on the video if I didn't go too fast. And I would submit to you, I've got a couple of cases for you to look at. There is a Court of Criminal Appeals case from 2007, 237 Southwest 3rd, 720. I've got copies for the state too, but it's St. George v. State.
Yes, sir.
There is an opinion with some negative treatment from 2018. Lerma v. State, but it doesn't overrule St. George. It does, and I think it's the Lerma decision is distinguishable from the current facts. And then I'd also point the court to the Supreme Court case from 2015, Rodriguez v. US, which is 135 Supreme Court 1609, and that is kind of the most recent controlling law on delayed detention stop. What I would argue to the court based on the cases is that in St. George, the Court of Criminal Appeals found that it was unreasonable to suppress a marijuana search incident to an arrest when effectively it's a passenger in a car that they encountered. They ran warrants. He failed to ID, gave a fake name. They ran for warrants, didn't find warrants. Delay the stop, knowing that he's failed to ID, and then search him incident, find marijuana from there. And the Court of Criminal Appeals basically says in that case that even though they were aware that criminal activity was going on, it's still unreasonable to delay it. And that delay was only about 10 or 15 minutes. And then in Lerma, that does give some negative treatment to the idea or the ruling set forth in St. George. It doesn't overrule it, but that situation is vastly factually different. It involves a stop, a warrant check, a delay, and then the defendant runs away. They later find him, and based on, I think it's pretty easily factually distinguishable from what we do here. So I do think that obviously this kind of encounter trips the Fourth Amendment obligations, and we're arguing, given all of these circumstances, that Your Honor should suppress the entirety of the case based on what that forth is saying. You've got authority to do that. Rest. Thank you.
Thank you, Mr. Thorson. Any response by the state?
Yes, Your Honor. I will mention that in the beginning of this case, almost immediately, Officer McKee, one of his statements is immediately how much marijuana. There's an overwhelming odor of marijuana. There is marijuana eventually found, obviously not in the vehicle when she's in the vehicle because it is on her person. Officer McKee begins his investigation, immediately has probable cause, begins searching. There is no delay. It is an ongoing investigation from the beginning until basically the moment he says, okay, I'm just gonna write you a ticket for paraphernalia. He does find what he believes to be a marijuana pointer in the vehicle. At that point, he runs her. The primary purpose of this stop is an intoxicated person immediately forms probable cause. That probable cause doesn't go away until he says basically, okay, I haven't found any marijuana. It is sufficiently hidden at that point. I'm just going to write you a paraphernalia ticket. He runs her. That continues. He immediately then finds a warrant and arrests Ms. Young on that warrant. I believe that this detention is not unreasonable. It's not unduly extensive considering it is a DWI investigation. I will also note for the court that it's not that the trooper doesn't say he does not really say she's not intoxicated. he says, basically, when I started talking to her, she was very intoxicated, when she was driving, but now she is coming down or it's less intoxicated. I'm not going to arrest her for DWI. I believe he believes he has a weight issue because there's some question about how long she was there, whether she was driving. I don't think it's an intoxication issue. I think it's we can't put her intoxicated behind the wheel of the car. And now that she has family, she is no longer a danger to herself and others. So public intoxication is not really going to be a factor at that point. So at that point, all what he's got left is there's paraphernalia. I'm going to write a ticket. That is the primary purpose of the stop. He then runs her, finds she has a warrant, arrests her for. Alternatively, state would argue that even if you find that that is unreasonable, we don't believe it is, but if the court finds it is, we can differentiate all these cases because all those are warrantless arrests. This is a arrest subject to a valid partisan parole. The second he finds she has a warrant, whether he has reasonable suspicion, probable cause, anything before that, he is aware that there is a shall arrest warrant, he makes an arrest, she's taken to the jail and arrested. If the court believes that the stop is unnecessarily extended, the court, I believe, should suppress the search of the vehicle, the DWI investigation, those things, but it does not go to the facts of the possession of a controlled substance at correctional facility, because that is all subject to a valid arrest warrant. Therefore, all these extending the stop, probable cause, reasonable suspicion considerations do not apply because it is subject to a valid warrant. Thank you.
Thank you, Mr. Woodward. In response, Mr. Thorson.
Respond, all right, I think that, if you find it's unreasonable, Wong Sun, otherwise, fruit of the poisonous tree, I do think applies because it is a search incident to an arrest, and I do think that, the case, the St. George case for you does involve a warrant and a search incident to a warrant, and the court criminal will still say it's unreasonable stress. And Your Honor, I would say that there is at least some acknowledgement by the officer at 10:14 on the video that he admits that he held the return and he says something like, "It's my fault that I held the return." So I think there's some acknowledgement, even on the part of the arresting officer, that there's an issue here. I appreciate your time this morning. Thanks.
All right, thank you, Mr. Thorson. All right, court's going to take the evidence and arguments under advisement, and we will reset this matter for the court's ruling on, are you available on February 23rd?
Yes, sir, I'm checking. I am. It is a possibility that I'm going to be in Berg trial that week, and I'll know tomorrow if it's continued. If you want to set it for that day.
What about March 7th or 9th? If you go to trial, you think you?
I would definitely get that. And I think that either day is, well, this is the 9th.
All right, let's do that then and avoid any potential conflicts.
Sure.
All right, court will set Ms. Young for status on the court's ruling on the motion to suppress for March 9th at 9 a.m. and just plan on being here in this courtroom.
Thank you. I hope that the repairs are repaired.
You and me both.
Okay. Do we need a? sign this?
Yes, you'll need to fill out a reset form, have her sign it, and put that March 9th date on there.
Ready to take it out on citizen.
Okay. I'll have exhibit one. I'll piece that together. All right, Mr. Mean, who are you ready on?
Judge, I'm ready on both Ms. Simpson and Mr. Payne.
All right, Jerica Simpson, CR 20225. Yes, Ms. Simpson, come on up with Mr. Manning. This is hearing on motion to revoke.
Yes, Judge. I've spoken to the prosecutor today, and Ms. Simpson had made sufficient progress that we would like to continue her on the status docket for the delinquency. We're additionally going to be requesting, I spoke to Ms. Ventura in the probation department, and based on Ms. Simpson's needs, she may be qualified for reduced community service payment that would help her close that gap of delinquency. And so we're going to ask for that. We've also been able to confirm community service that's been caught up, as well as she provided documentation of leading on her classes that I think is addressing some of the base underlying issues in her difficulty to complete probation.
Okay, and how long are you requesting a reset for?
If Your Honor would request a 30-day reset. I don't reasonably expect Ms. Simpson to be in compliance in 30 days. However, state would like to set it for that date just so we can measure. I don't want to set it for 60 days and have no update and then find out that there's been no progress made. State has reviewed the things that Mr. Manning submitted. I do believe that Ms. Simpson is making the best of her ability progress. I've also offered her an alternative resolution to this case in the event that she wants to take that. But as long as there's substantial progress, the state is comfortable resetting this and letting her work back towards reinstatement.
All right, do I have probation in here?
Yes.
Ms. Burns, have you met with officer? Are you familiar with this case and the information they're talking about? Is Officer Matura?
Ms. Griffith is her probation officer. She's not here, so I just speak to Ms. Matura about this, and she was able to provide the information.
All right, so you believe that probation is supportive of the proposed?
I explained the Simpson situation, and Ms. Ventura said that the biggest challenge for Ms. Simpson is going to be getting caught up in that financial obligation due to her living on a fixed income and not having job opportunities. And so that's when she provided me the information about the qualification process for a reduced reporting fee. And so I think that's going to greatly assist in the Simpson getting caught up and back in the good state.
And I'm not familiar with her motion off the top of my head. What are the major violations in your opinion?
Judge, she has been on status on this for a couple months now, so I know that there was a positive test for THC alleged April 8th of 2022, and the rest of those items were technical violations of failure to report, failure to pay, failure to do supervision. I'm sorry, no, not failure to report, sorry, failure to pay and failure to communicate.
That's an important correction.
Yes. Sorry.
Very important. Okay. All right, court's going to reset Ms. Simpson for another status on February 23rd at 9 a.m. All right, Mr. Van, who else did you say you're ready on?
Also ready on Mr. Stanley.
Dennis Ray Stanley. CR 22340. Believe Mr. Stanley is set for pretrial.
Yes, Judge. We were set for pre-trial today. We received an offer from the state. I think this week, at least we discussed it, and we received a counter offer, or we proposed a counter offer, which the state got back to us yesterday. I believe that we're going to be reaching an agreement on that. And we would request this case to be reset for hopefully that. We request that on the March 9th day, if that's possible.
All right, court will find that there are no contested pretrial motions. And the court will set Mr. Stanley for plea on March 9th at 9 a.m. And Mr. Stanley, do you have conditions of pretrial release? Have you met with the pretrial release department? You've done that? Okay. All right, then once you sign and get the yellow copy, you're free to go. Good to see you. Okay.
Hey, Mr. Stanley, excuse me.
Yes, you're excused. Anyone else at this time, Mr. Manning?
Yes, Judge, I just have seen Mr. Chin on the flash.
All right. It's the last name of Flash.
It's Tienda. CR 22002.
Because I have Avery, Clement, LaFlash, Tienda.
I believe it's the flash Tienda is hyphenated.
LaFlash, Tienda. I'll need to get that fixed.
I'm not sure which order it's in. I have. I believe it's hyphenated Tienda La Flash.
Tienda, LaFlash.
And
Okay,
I believe that's what's on the.
I say our system, Judge, we don't have a hyphen, but we have Tienda space, Flash as his last name. Avery is the first name.
And that's what on the order of appointment is how it has it as well.
yeah, the Docket, it's not even close to that. All right, Mr. LaFlash is set for pretrial.
Yes, Judge, we have no contested control at this point. We received an offer from the state. And we're continuing negotiations. We request we set it on the call.
And we still need a TRN for Mr. LaFlash.
No, Judge, that's Mr. Spencer, and I believe he's been sent. Oh, I don't know where that.
Do we have that order? Do I have it? Mr. Mc, there you go. If you give that to Mr. LaFlash. All right, court will set Mr. LaFlash for docket call on March 9th, 9 a.m. And Mr. LaFlash, that order, I need you to go out to the Justice Center, to the jail on Highway 64 west from here. Take that order in there and they're going to take your fingerprints. Okay, they're going to take your fingerprints and you'll be free to go after that. Okay. All right. And I need you to do that as soon as you leave court. All right. Mr. Waddell. Any update on Mr. Roscoe and his drug test? He was fine. He's fine. Yes. Okay, so he's free to go. Yes. Okay. Ivan Rostro Garcia. All right, Mr. Rostro is set on motion to adjudicate today. It's my understanding that the defendant wants to enter into a plea agreement with the state. We'll set that on February 7th at 1:30. So Mr. Rostro, you'll report to the Van Zandt County Justice Center to the jail at 1:30 that afternoon. They'll let you in the back, okay? It's my understanding that you'll be accepting a 6-month state jail sentence. And the court will also let the record reflect that Mr. Rostro was negative on his drug test today. You're free to go, sir.
Thank you.
Yeah, you stay right there. I don't know where they're putting them. Just see it. Yeah, I don't see. All right, let's see. Guess we're up with Mr. Booker now.
Mr. Platt is upstairs on Zoom. I think we've reached an agreement on what we're doing paperwork to that effect. We're waiting on that and for Mr. Platt.
And I believe that Mr. J. Sean Spencer for Mr. Manning, he appeared and we sent him to the jail to do the TRN because we understood that there's maybe a plea on that. Is that correct?
We can't do the plea paperwork
Without the
How
TA.
we get the TRN, we're gonna do that, and then we may have to do him this afternoon, but we'll still be here, so Mr. Manning can just have to run back. We'll get it done.
Okay. Okay, all right, Mr. Booker, come on up. This is cause number CR 22-239, State versus Jimmy Saul Booker. And Mr. Booker, you can have a seat right there. You don't have to stand up at this time. And all right, I believe that we are set today on Mr. Booker's motion to dismiss. I saw that there was a motion to quash that was filed outside of 7 days from now. State's position on the motion to quash.
Judge, the state's comfortable taking it all up at one time. Mr. Booker and I were able to put it before court. If the court would indulge me in kind of running through kind of what our game plan is.
Yes, ma'am, go ahead.
All right, Your Honor, Mr. Booker's motion to dismiss the indictment that was filed on December the 6th of 2022. The crux of that motion, Your Honor, is based on the charge of failing to register his vehicle and report that, which would have been a violation of his conditions of registration. Mr. Booker and I have discussed that. That was originally in the arrest warrant affidavit as a charge. However, the state reviewed that. State agreed with Mr. Booker that was not an appropriate charge, and that charge is not reflected in the indictment. So it is my understanding, Mr. Booker, correct me if I'm wrong, that Mr. Booker is going to withdraw that motion on the basis that he and I agree that the state is not charging him with the offense of failing to register based on the registration of the vehicle.
Correct. Okay. All right, so the court will grant Mr. Well, and so Mr. Booker, you are making an oral motion to withdraw your motion to dismiss. Okay, all right, the court will grant Mr. I'm sorry, you gotta say it a little louder.
Where you go first, for the court to take years notice. So in fact, saying. That portion of it, I'm not gonna strike from the back. So I'm about to address it again.
Ms. Heisel.
Which issue specifically would you like the court to take judicial notice of?
Okay. Basically, what I'm saying. The initial response. The judge specifically. The town meeting. The judge specifically states. How. What I need to valid. Registration. And they left it open. The arrest warrant, they want to go and tell them how to get it in. All it says is that man, you read I committed the offense. Violating 62, 51, 102. Yes, the actual warrant test, it has no specifics about what's supposed to be seized or something. But in this affidavit that was presented to the magistrate to issue the warrant, I want to, the third paragraph down, John the window, George officer, said she has also discovered that I have social media accounts that I did not address. Facebook and TikTok account. She provided those attachments. When I reviewed the district attorney's record, those were on the record I saw. I filed my motion for discovery. You advised me. And I saw a pre-page, basically what I already had. Today, this attorney has another document, which is a warrant that was issued in October of this year. Now, I recall that I got arrested in April, on April the 23rd, and I was released from jail on May the 15th. What our position is to pursue, is to pursue the second portion, Facebook account, as a violation of my terms or conditions of the road. So my point is this, that the document didn't exist at the time that I examined the DA's record. As the date shows, which is done in December, October this year. I'm also arguing that Dawn Williams, she admits to it in her affidavit presented to the man, so that's the initial one. I'm arguing that there was an illegal search and seizure of my account by her going into my account without a valid warrant to look for information. The warrant is not saying what she's supposed to say for. And I mentioned that in my motion to suppress. So it appears that the DA's office has placed for me another third procedure warrant. So I haven't been arraigned or anything on this second warrant that recently presented to. I don't know. I have evidence which would be my direct from the district clerk's office. After I got out of jail, I went to my family, and I asked him, were we scheduled for court? His exact words was, Mr. Booker, I don't see us going to court anytime soon or in the near future. I followed that up this another day, July 13th, with the court motion against me. And I went to the district clerk's office. They went back 4 years. A criminal felony bracket and civil search was performed on July 2nd, 2018, on the above date. The search was performed to present date, was July 13th, 2022. There was no felony criminal case or civil case found. Where was these records at? There was an indication against y'all. It's like what just got added on paperwork. So my position, Peter John. Is my point is this. And it's troubling about his case. if this clerk's office conducted records search on same case, and went back as far as July 2018, and couldn't find the case on record at all. So we got two separate warrants issued defining the same needle in a haystack. When the figure register didn't work, they went looking for a needle in a haystack. That's when the site, social media campaign up. Now, if we dismissing the case altogether, why should there be a second issue coming up? When the same, I don't ask the court to take judicial notice of it. In my judgment, that both my motion to dismiss as well as my motion to suppress the evidence that was initially obtained as a result of an illegal search and seizure. It violated my rights under the 4th, 5th, and 14th Amendment U.S. Constitution. My point is the state prosecutor's office was tipped off to the Facebook account that was legal through that first affidavit.
I think that this is what would be helpful for the court, and Ms. Heisel, I'm gonna let you respond, but I want to start with the indictment and I want to do a timeline, and I'm gonna need to see these warrants, because I don't have these warrants you're talking about, because we've not gotten that far on the hearing to where the warrants have been admitted into evidence for the court to review so that I can follow the logic of your argument. So Ms. Heisel, do you want to respond to anything that Mr. Booker said at this time?
Your Honor, in the beginning of the hearing, I was trying to distinguish the motion to dismiss separate from
Motion to suppress.
suppress, because I feel like there are two separate issues contained therein. I also, from hearing Mr. Booker, the first warrant that he is referencing as Exhibit A, which he did attach to his filings, and he would have no objection if he wants to offer that. That is the arrest warrant for Mr. Booker that was issued, I believe, in April. Yes, the 20th day of April.
That's it.
Yes, Mr. Booker, would you like to offer that to the court for consideration?
These say are attempts to my motion to dismiss.
All right.
Motion.
All right, let me see if I can find that.
You're attached to the motion to dismiss.
All right, the court will take judicial notice of the defendant's motion to dismiss indictment filed with the Van Zandt County District Clerk and any attachments thereto. And the court finds that there is no warrant attached to that in the clerk's.
The warrant is attached in Exhibit A2. The affidavit is Exhibit A. The arrest warrant affidavit is Exhibit A1, Exhibit A1, and the arrest warrant itself issued is Exhibit A2.
I'm telling you that what the clerk's office has scanned in does not have any type of warrant attached to it. The first document is entitled. Let me see, that's the suppression. I've got motion to dismiss indictment filed December 6th, 2022, and it consists of handwritten pages only. Appears to be 3 handwritten pages. It says 4 of 4. One of those is blank.
And Judge, I have that the motion is 3 handwritten pages, however, the clerk's office did forward to me, attached exhibit A1, and A. So I have what Mr. Booker is telling me that he submitted, I would have no objection to him offering that at this time. The court doesn't have, if the clerk doesn't have the record, but the
I
clerk
see.
did indeed.
Now I see a separate filing entitled Exhibit Checklist Document Exhibits, but it was not scanned in with the motion. Let me see if that's it.
That may have just been the way the clerk put it in, Your Honor, because I received it as a complete document.
What significance would it have if the clerk don't have any wrap up documents of the case?
All right, court finds that there's a document anxiety. We gotta talk one at a time, Mr. Booker. The court finds that there is an exhibit checklist. Court will take judicial notice of that. It appears to contain one handwritten page and then the arrest warrant affidavit in WPF 2022 9, arrest warrant number listed as exhibit A, along with the warrant, the arrest warrant for that same cause number. And then another handwritten page entitled Bill of Sale. Another exhibit that appears to be a Texas certificate of title. Another document that appears to be a letter from the City National Bank. An application for Texas title and or registration. Another document entitled Rules Point Police Department Sex Offender Registration Packet, Exhibit B2. Another handwritten page entitled Affidavit of Kimberly Mathis. Another handwritten affidavit of Walter can't pronounce, I don't know what his last name is. I can't read it. Maybe Mallacoccio, maybe. And then a printed page from Karen Wilson, District Clerk, which appears to be a letter issued on the day that a search was performed, that there were no felony criminal cases or civil cases found, dated July 13th, 2022. Is that all the exhibits you're referring to? Okay. All right, court will take judicial notice of that exhibit list contained in the clerk's filings on December 6, 2022. Okay.
So Judge, state would distinguish the arrest warrant contained in Mr. Booker's exhibit A, A1 and A2. It would distinguish that from the search warrant for the Facebook records in Mr. Booker, which was issued on October 13th, 2022 by this court. So I just want to make sure the record is clear. There are two separate warrants. One is the arrest warrant, one is the search warrant. I think that is part of the confusion here. As to Mr. Booker's assertion about the filing of the clerk's record, we would ask the court to take judicial notice of the indictment in this file. And that did have a return date of July 15th, 2022. So on the 13th, when Mr. Booker came to have the clerk perform a search, there was nothing in their record yet because the case has not been indicted yet. However, July 15th, 2022 is well within the statute of limitations for this case, 3 years from that April date. So we would ask the court to deny Mr. Booker's motion to dismiss on that ground.
Response, Mr. Booker? Do you understand the argument that Ms. Heisel is making?
I understand the point. But my position on it is since the evidence that's gonna be the court dog, it's whether or not I have a social media. The evidence was obtained in violation.
Okay, and then tell me how so.
Before to me, there was not a child warrant specifically stating to go into private. She went into that account and got that. She leaked that evidence, which is the basis of why she wanted to do that. Because basically, my position was what I was illegally arrested in the town. And to keep from it being an illegal arrest in the town, they're trying to put in the tail on the dog. It's already done in the first motion. If you dismiss the first motion, I've already offered that. In the motion to dismiss. The motion to suppress the evidence here today. That I made. Is that this thing ain't going back and forth, back and forth. That if I was legally arrested, I'm not saying the warrant wasn't valid. But I'm saying the charge is false. And I proved that in my motion to dismiss. The last term we had, that's why she didn't offer that. Now she wants to take the same evidence that was leaked from the first one, I thought. And use what's been leaked to her. Because the initial charge was found that she had made a mistake. When she charged me with failure to register in the registration record, worked the same day that I registered, she had a warrant.
And I want to make sure that the record is clear on this. I believe when you say that you were arrested for failure to register, you're actually referring to failing to register your motor vehicle with the sex offender registration office, correct?
Right.
Okay, I want the record to be clear on that because you're charged with failure to register as a sex offender. If we keep saying failure to register, the record's gonna be confused. So when you say you were arrested for failure to register, you're not talking about being arrested for failing to register as a sex offender. You're saying failure, when you were arrested by Officer Wheeler, you're saying it was a wrongful arrest because she arrested you for failing to register your motor vehicle, correct?
Right.
Okay, all right.
But that was the basis for her to what? Illegally going into my account and searching her for other things. It's the same thing that the prosecutor trying to fight for.
Okay, let me ask Ms. Heisel some
That's
questions.
a
All
portion of that.
right, so Ms. Heisel, can you respond to Mr. Booker regarding the search warrant versus the arrest warrant?
Yes, Your Honor. And I would offer at this time, taking exhibit one for the limited purpose of this hearing, which I provided to Mr. Booker this morning, which is the search warrant, affidavit, issued warrant, and warrant return. Do you have any objection to gave us before?
Yes, I object to it because first of all, I haven't been arraigned on that. I haven't been arraigned for that, and even if I've been arrested on that warrant, but what I'm saying is.
Well, this
was
is,
formed from the leak.
I understand. I understand. So a search warrant is not an arrest warrant. So you will not be magistrated on a search warrant. Do you have any legal objection as to the admissibility of that document for the purposes of this motion to suppress hearing?
I'm object on the ground that it constitutes double jeopardy then. I'm being put twice to answer to the same thing that I've already got.
Which you understand that's not an arrest warrant.
Right.
Okay, all right, the court's going to overrule your objection as to double jeopardy and failure to being magistrated. So the court will admit State's Exhibit 1, the search warrant affidavit for the purposes of this motion to suppress hearing only.
My point on the suppression.
Well, hang on. It's her turn right now. I've asked her to address this, so I can't have you hopping in and out. So I'm gonna let her explain some things and then I'm gonna come back to you. Go ahead, Ms. Heisel.
Thank you, Your Honor. Judge, I believe that this, I know we're kind of taking all of Mr. Booker's motions in one lump sum. I believe that this goes more to the motion to suppress than anything else, Your Honor. In Mr. Booker's motion to suppress, he argued that it was an invalid search because there was no valid search warrant. We have just offered for the court the search warrant affidavit and search warrant that was signed by this court on the 13th. So we reviewed his assertion that there was no valid search of the Facebook account. As to the what I believe Mr. Booker is calling a search, I would disagree with that terminology, but back to the April arrest warrant, it does mention in there that Officer Wheeler has located, Mr. Booker does have some social media account, which he did not report or disclose on his registration form. That is the basis of our charge against Mr. Booker. That is the violation that he is indicted for. That, from my conversations with Mr. Booker, it sounds like he asserts that is a search. We would argue that there's no reasonable expectation of privacy in a public Facebook account, whether somebody has a Facebook page or not. As to the intricacies of that Facebook account, there is a valid warrant. So we would review both of Mr. Booker's claims as to that and ask the court to deny or motion to suppress the problem.
All right, go ahead, Mr. Booker.
My argument is that in the illegal search. And not only that, the warrant that was issued to my arrest from a magistrate did not authorize search of my account.
Okay, so you're arguing it. Show me the evidence and explain to me how. You have a burden to meet on that. So you can't just say you're arguing it. You got to explain to me, why is it illegal?
It's illegal because my
Well, that's the law. Argue to me how that law was violated.
that law was violated because she's not allowed to go into my private account and just search looking for what, I mean, if that was the case, then she could come in my house without the one for any specific reason. Come in there and search it. If I say, she was looking for a shotgun. And that warrant was specifically state what she told those search for. Anything else that she sees in my house, whether it's legal or not, would be barred from being used. She couldn't use that, she couldn't use anything other than what that warrant in her hand. This was a pretty interesting issue. She wrote the warrant on the same day that I registered. Same day that the people was registered, she writes the warrant. So her motive was what? Let's find out some dirt on him, see what all he can do.
Well, that's probably her job as an officer who is responsible for making sure that registered sex offenders don't fly. Hang on, I'm talking one at a time. That's her job as an officer, is it not, Mr. Booker, to investigate, to make sure that the people she's in charge of, which are registered sex offenders, are complying with the law that makes them register their address, their vehicles, where they work, and make sure that they don't have social media, correct?
Right.
Okay.
Do we lose those rights? And
Yes.
where's the harm in?
Yes, you do lose those rights.
Where's
As
the harm in going into it?
where's the harm? Well,
Where's the harm at? Why did the stipulation exist?
well, Mr. Booker, what I see here in State's Exhibit 1 is that Officer Wheeler is saying that she went on to Facebook and just typed in your name or TikTok. She says that she's discovered that you have social media accounts that you did not register. Jamie has Facebook and TikTok accounts. Going as, and what I hear Miss Heisel arguing is that anyone can go on to Facebook and TikTok or any other social media and determine if someone has an account. And as a registered sex offender, registered sex offenders are required to disclose those social media accounts. And so seeing that you going into the internet and seeing that you have a social media account is not a search that's protected by the Fourth Amendment. Going into your account with the holder of your account, TikTok Corporation or Facebook or any other social media, and getting your personal information, chats, downloads, things of that nature, Could be, but she requested a warrant for that.
Does it deny you to protect?
Does it deny you? Does what deny you?
This ain't, where is the home?
Where's the harm? So it's, you're required to disclose that.
And that's the stipulation. Or the law.
That's the law. I believe that's the law. Is that correct, Ms. Heisel? Just like, so to use your example of wanting to find a shotgun and come into your house. If you are a convicted felon and you are possessing a firearm and you are possessing it at some place other than your home, then that's a right that you lose under the laws of the state of Texas. And you don't even have the right to do that if it's within 5 years of your release from prison or parole.
Back to your same point. If the one authorized doesn't come in and find a shotgun, and she doesn't find a shotgun, but she finds marijuana. Does it give her the right to put a charge with marijuana?
It does give her that right, but it's a different legal issue than what we're dealing with here. If an officer goes into a place with the authority of a warrant, and once they're there in their presence or view, another offense is being committed, they have legal authority to be where they're at, and they see evidence, they can seize that evidence, and they can issue another warrant to make a further search of your house if they want to. But that's not the issue we're dealing with here today. But I wanted to answer your question.
One other question. Then it goes, the case that being healed, I've been arrested, I'm being detained. And the rapid disapproved. Was that an intent to dismiss the case?
If the what disappears?
If the clerk can't find the record, the case on record. And she did a 4-year search and there's nothing in the system that shows that I didn't get charged with something.
And Mr. Booker, let me ask you some questions. When were you indicted for this charge? What's the date of the indictment?
Yeah, 15, 2 days after I got with my family. They decided to go do the suit.
So July 15th,
My
2000.
motion dismiss council filed on July 13th.
All right, so July 15th of 2022 is when you were indicted. And when was your record search?
The record says it was on the same day. I'm not on the 13th. The record says it was on the 13th. The same day that I went to my attorney's office and he said, you don't know what happened to the case. You couldn't find it. Scheduled for court again time soon or in the near future. So I decided to follow that tip and go to the clerk's office and see if she would do a record search. There is no place even.
So the record search that I see from Ms. Wilson's office is dated July 13th, 2022. And what is the date of your indictment?
2 days later.
2 days later. So if the clerk is looking for records, they can't go forward of records they don't have. They have to go backwards. Okay, and so they're looking from July 13th backwards. 2 days later, a record was filed. That's why you don't. So what, but what is your question?
Why are there no records of me and it being in jail?
Because the clerk doesn't maintain those records. They maintain judicial records. And those are records of indictment and anything that is filed into the case after that. They don't hold booking records. They don't hold check records from the county. They don't hold every record in the county. They're only going to hold things that are filed with the court, such as an indictment or a motion to suppress or a motion to dismiss. And so your record search is not going to pick up records that occurred after the date of the search. And I see here that the indictment is dated July 15th, 2022, and your record search was completed July 13th and would cover anything prior to that. Does that make sense?
So I mean, I understand the time. But basically what I'm saying, we're not prosecuting you. And if she got a case standing, we got a call, we're gonna do it. And I'm being detained. To not have a record of you.
Well, I'm sure that she could get a record of you being in jail if you were being housed at the sheriff's office.
Things, just good. The same way,
Is the state required to file all of the records of you being in the sheriff's office? No, she's not. She's going to file typically the case records, the indictment. She's not filing the police reports. She's not filing when you've been booked in. She's not filing when you posted a bond. The prosecutor is going to file the things that are relevant and pertinent to your case. That's not going to be public record.
should they not reply to any of my motion?
Well, is that part of your motion to dismiss and your motion to suppress today?
Dismiss the motion to suppress, and you also order us to file our discovery, anybody, we intend to call as a witness.
Mhm.
I haven't received that.
Well, we're
She
not,
hasn't filed with it.
I understand, and we're not,
It's your letter.
and we're not set for trial yet either. We're gonna deal with these motions today, and then if I wouldn't order her to produce a witness list if she was gonna come in here today and say, I agree with Mr. Booker, let's dismiss this case. We're gonna get through today's hearing. I want to make a ruling on the motions, and then we're gonna figure out what the next setting is for docket call, jury selection, and then sometime she'll produce what she's ordered to produce.
In your ruling, you also respect finding and concluding.
I can make findings of fact and conclusions of law. Anything else any other further arguments on your motion to dismiss and your motion to suppress?
I would consider any statement that I made this hearing, you consider, I'll take you this motion as in the meeting.
All right, court, yeah, the court will consider your testimony in its rulings. Anything further from the state?
Not on this motion, Your Honor.
Okay, all right, the court will be in contact. The court's going to consider the arguments. I'm going to review the evidence, and I will contact the parties when I'm ready to issue a ruling. Okay, so let's go ahead and make another setting today. Of course.
All right, before we move on, Mr. Booker also filed a motion for discovery, and if the court would grant us, allow us to make a record on that.
All right, go ahead.
Your Honor, I believe that the state has complied substantially with Mr. Booker's motion for discovery. We have, by our policy, because Mr. Booker is not represented by an attorney, we have not physically released any discovery to him. However, he has been in our office. We have opened up the file to him, and I believe we've provided him access to everything that we have. If Mr. Booker wants another opportunity to come review that in the future, we would be happy to make accommodations for that. So I just wanted to establish for the record that while we have not given Mr. Booker anything to take home, we've made the state's full file available for his inspection up to this point.
Mr. Booker.
I'm gonna get to her, trying to produce discovery evidence at this point. You gave her like 3 months ago. File out discovery. Currently, she didn't intend to offer any evidence or call any witness.
Well,
I found my motion and she hadn't released anything. If she had, even the documents that she just sent to you. It's not giving me a fair opportunity to respond. She should have did it by a motion and put it on record where I could file it back.
well, the motion, it's your motion for discovery. What she's indicating to the court today is that she has made her file available for you to go over there and read and review. But what she's indicated is that she's not produced a physical copy of that discovery. And she's not talking about asking the court to consider that discovery today. She's talking about in anticipation of going to trial and making sure that she complies with the court's standing order, and also to agree with your motion for discovery. So she's talking about
She just now wanted to respond to the motion for discovery.
Rob, there's no deadline at this point because we haven't set for trial. So she still has time to What I'm gonna do, order Ms. Heisel is because Mr. Booker is pro se, I'm gonna order that the state produce a physical copy of the evidence that the state intends to, well, I want all evidence under Morton and Brady, but I'm gonna direct the state to redact any of the personal identifiers of any of the witnesses that may be disclosed in that discovery and produce a hard copy for Mr. Booker. So he has the ability to take that home, review it, make his notes, so on and so forth. And we're gonna go ahead and we're gonna set the next hearing for ruling on the court's ruling on motion for motion to suppress and motion to dismiss. We'll come back, let's come back on February 23rd. And that'll be at 9 AM. So we'll come back on the 23rd, Mr. Booker, and I'm likely to already have my ruling before that date. And if I do, I'll make sure that we email it to you. Do you have an email?
Yes, sir.
All right, and if I'll also give you a hard copy on the 23rd if I have it in hand. All right, does Mr. Booker's got your notice, so you're free to go, sir. You have a good day. Wait a second. Yes.
Check, let's see if you got the records that left yesterday on Saturday, as far as these.
Patty did. Yeah, she told me that he was confirmed in the behavioral health center. So you're good on that nice side. I think we already set him for another day, right?
Yeah.
Okay. Yeah, you're good. Ms. Heisel, can I see you real quick? Sorry. You need a break still? Is it gonna be short? Is it gonna be short?
It is.
Okay. Who are you ready on?
Mr. Ward,
All right, Mr. Ward, step on up, sir. Michael Renee Ward, CR 16161. We were status delinquency to probation, I believe.
Judge, he is all caught up. I've been announced to confirm that. We are waiting for ultimate confirmation on his probation fees. He paid that this morning. There's just takes a couple minutes, but he does have a receipt number. As well as the receipts from court costs that have paid. They originally got paid downstairs. It's back that transaction out, but they haven't paid upstairs as well. We have that confirmation. I provided that to the state. But they have an oral motion.
Judge, we make a formal motion to withdraw and terminate Mr. Ward's community supervision Because we have new computers, I can't print right now, so I will present that, the paper to you this afternoon, we would make that all.
You said we have receipts for payment to community supervision and the court.
We're waiting on payment, the actual receipts to community supervision, like I said, it takes 12 days for the system process, but they were in quantity that have a receipt number.
And it's gonna be a withdrawal and terminate or withdraw and continue.
That's correct, Judge.
Terminate. All right. All right, then the court will grant the state's oral motion to withdraw the motion to adjudicate or and also the court will terminate the community supervision of Mr. Ward, finding that he has satisfied the delinquencies. And the court will sign that order when it's presented by the state. And Mr. Ward, you're free to go. And Mr. Manny, that took care of your fees and attorney fees and.
He paid whatever balance was up there, so.
But that meaning that you're not going to turn around and bill the county.
Judge, I don't know, each month I sign my name on it, but
I mean, did we factor that in collection of new attorney fees? You see, my concern is we're gonna pay you and Mr. Ward's not gonna reimburse the county. Do we know, let's check in to see how much we had assessed for attorney fees in your office.
he paid the complete balance that had been assessed by the court.
Yeah, and I understand that, but there's gonna be no. Yeah. I mean, we typically assess $500 on contract on the new one, so. Let's and they wouldn't collect that without a judgment. They wouldn't collect that without paperwork from us, so that's telling me that we still have one issue to resolve.
Well, Judge, I know he's satisfied the conditions of the outline from the state, and he had to beg, borrow, not steal, to get that covered. So I don't know. Like I said, we fulfilled the obligation that we had negotiated. I understand the court's concern. I just know that he has been several months coming, trying to get this money. And it's not all done for him as well.
I understand, but I feel like I have to look out for the solvency of the county and for the best interest of the citizens. What I can do is we can reset Mr. Ward. We can set him out for 90 days and give him time to come up with the final payment for reimbursement of attorney fees. And he wouldn't otherwise be on probation, right? You agree, Ms. Burns? Wouldn't be no need to report to your office for further compliance. It would just be a financial status. So we could set him out 3 months, and if he can only come up with 150, then we'll reset him until he gets it paid off and not make too much of a inconvenience in his life. But I think he needs to reimburse the county for what it's expending on his behalf.
Well, and I haven't inquired as to his exact financial status prior to this hearing, but I would note that the case law does indicate that those that have been found indigent, that burden to reimburse the county would be on their current status, ability to pay. And so what I may do is speak to him and see if we need to, at that 90-day mark, have another hearing as to his indigency status, if he's unable to.
I believe I found him indigent with ability to reimburse. I mean, we can take some testimony now and kind of go over some of those things if you
Well,
want.
like I said, I haven't had an opportunity to speak to him about that, if there's been any changes in his status, so we can do that the 90-day mark before we set this case.
I mean, if you want to, you can go talk to him right now if you want to, and then if you want to come back in and argue it, I'll certainly consider it. Did Mr. Spencer return? I've already dealt with Mr. Spencer.
He went to the jail to get his fingerprints, get a TRN, and that has to go to the clerk's office and get sent to our office for paperwork. I told Mr. Manning you probably would be this afternoon, very when they had his client this afternoon. Take care of this. It's just a processing issue. I would be opposed to, just letting.
Okay,
Refund it on there.
okay. All right, so we'll just put Mr. Spencer at 1:30 and then we have paperwork on Mr. Platt's client.
Mr. Platt has the paperwork, Mr. Watson outside of Mr. Platt's bill in here. Could be fairly.
I thought he had one hearing. I didn't know it was gonna be 2 hours. Let him know that we're gonna be breaking at 12, so.
One of the, when I handed in the paperwork, I heard him say something about judge of 3 cases. It may be 3 cases for one client, something of that nature. I'm not relating to the court. There's multiple cases. I heard him say 3 cases that may be one setting for, he's got 3 cases for one. I don't know. I'm not. I just overheard him announce to the court on Zoom. He was announcing that. I don't.
Judge, I was sort of my.
You don't need a record, do you?
No.
Okay, go ahead.
I spoke to my client and he has a couple job interviews coming up that he's very hopeful about. He's been working off and on as maintenance. And that is what allowed him to get payments paid up. I think he will be able to pull that $500 obligation for 90 days. So we just reached out 90 days.
Let me ask you some questions. What was the total that he paid to probation?
Today.
Yeah, whatever he had to pay to finalize.
$1,500. So about $2,250. My math's correct.
Right, it says that the total I had written down was like close to 4,000. Is that all right? I had that he was delinquent 1,450 and that he owed 3,963.
He paid 1,500 upstairs and 775 is probation.
Where's this 4,000 coming from? Is this yours? Can you bring her down here? I'm suspecting that she collected the delinquency and not the total. So I'm suspecting. That's why I'm confused.
Okay.
Because I was about to say this. If he paid 4,000 here and 700 or whatever, I was gonna say. So yeah, thank
So
you.
you're saying there's an additional amount above and beyond what he was given by the court collections office?
Suspecting at this point, we're gonna find out on her. I had a total delinquency of, excuse me, not delinquency. I had a total owed of $3,963, and that was for fines and fees only, separate and apart from probation. And I had a delinquency of 1,450 on that fine and fee. And so what I'm hearing is if he paid 1,500 upstairs, they probably just caught him up on his payment plan on the old cases. And I'm not saying that's going to be a deal killer. I'm not saying that. I'm just trying to get to the bottom of it.
And Judge, if you'd like, I do have. Here it is. His training service. And then here is the payment to the county clerk that was withdrawn, and then to the, that was what he just got today. And then we have the receipt number for the payment.
All right, we're back on the record, CR 16161. All right, Mr. Ward, this is what I've determined, and this is what we're gonna do, okay? The state has made a motion to withdraw their warrant to terminate your community supervision. You've satisfied all of your community supervision conditions, including the payment of financials. Court finds that you still owe Van Zandt County approximately $2,500 for your past fines and fees not associated with this case, I don't believe, okay? And so, am I correct on that? Am I correct on that, Ms. Harmon? Is this for an older case? All right, so you owe the Van Zandt County, you still owe them $2,500 on this case. Okay, it's not being collected through the probation department. So what I'm gonna do is I'm gonna grant their motion to withdraw. I'm gonna terminate your community supervision. All right, and I'm going to let you pay out the rest of it with Ms. Harmon on a payment plan upstairs. You're gonna meet with her, whatever your payment plan is, that's what you need to pay every month. If you don't pay it, then the court's gonna issue a warrant for your arrest, and we're gonna go back to a very similar process. I'm not gonna charge you the additional $500 that the county's paying for your case. The taxpayers have paid Mr. Manning $500 to represent you. I'm not gonna make you pay that back, and the reason I'm not doing that is because if I were to put you in jail for the $4,000 that you owed prior to coming in here, then it's going to cost the county more money than the $500 that is given to Mr. Manning. Okay, so I'm putting you on the honor system here. I'm taking you off of probation, and I'm not making you pay the $500 that you should be paying. And I'm hoping that you're going to return the favor and you're going to pay the $2,500 that you still owe to the county for this case with Ms. Harmon. Okay, so there's, I feel like I'm giving you an opportunity here, and I hope that you appreciate that and you give it back. Okay, all right.
Just briefly, I want to make sure that Mr. Ward understands that if he doesn't comply with this payment plan, that a warrant will be issued for his arrest.
Yeah, that's what I told you.
There is a stake here still. It's not just you respect and understand what the judge is doing for you. If you don't pay, there will be a warrant issued for arrest. Keep these profile your attorney to explain. I just want to make sure it's not like you're just on the honor system. There are consequences if you do that. I just don't want it to sound like.
Well, no, and that's what I explained to him, that
Okay.
I said I'd issue a warrant. We go through a very similar process. I'm just saying, I'm taking you off for probation. So you're not gonna have a probation officer saying, we're gonna arrest you when you don't pay. It's gonna be Ms. Harmon who's gonna say to me, Judge, Mr. Ward's quit coming in. We set him up on a payment plan of 50 or 100 or whatever it is. A fee that's gonna be, or an amount that's gonna be very reasonable based on your income and your ability. If she says that you quit showing up, you quit paying, then I'm just gonna issue the warrant for your arrest, and we're gonna go back through this process. Okay? All right. I'm hoping not, based on what I hear that you've done so far. And so that's why I'm gonna kind of give you some credit here, okay? All right, so I'll sign that order once it's presented.
I will present this.
And so, Ms. Harmon, do you need to meet with Mr. Ward? Do you need to meet with him to make sure you have payment plan? Okay,
You know, to confirm that I come back at 1:30 here and go to jail, or
do you have a contested hearing this afternoon
no judge. I filed a motion for continuance on the,
on Raglan or whatever? Okay.
yes, and I also state what it was not to be available.
Yeah, I was going to grant that based on your motion. I haven't granted yet, but I was going to based on your witness stuff. So if you don't have any contested hearings, then you can just appear out at the jail.
Okay.
Is Mr. Spencer,
Here.
is he going into custody or is he on probation? Well, then I'll let you just come here. Come here.
First.
We'll do Mr. Spencer. We'll take care of it and then we'll let you go out there.
Excellent. Thanks, Judge.
All right, Mr. Platten, are you ready with Mr. Watson? Mr. Watson, come on up. This is cause number CR 18118, State versus Landon J. Watson. It's time for new prescription on my glasses. CR 18113. Mr. Watson, if you'll raise your right hand, sir, I'm going to place you under oath. So do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God. Thanks. So you can lower your hand. All right, Mr. Watson, you appeared before the court on June 21st of 2018. You pled guilty to the offense of abandoning or endangering a child. That crime was what level was that crime here? Yeah, it wasn't listed. State jail felony offense. After hearing the evidence, the court found that there was enough evidence to convict you. However, the court deferred a finding of guilt, placed you on community supervision for a period of 4 years. Your supervision was subsequently extended for an additional 2 years, which extended you until June 20th of 2024. It's been during your period of community supervision that the state has filed a motion to adjudicate and revoke, alleging that you have violated your terms of community supervision in 4 separate counts. Have you had an opportunity to review that motion with your attorney, Mr. Platten? You feel like you've had a sufficient time with him to have all of your legal questions answered? And is there anything about the paperwork, Mr. Watson, that you've read over that you do not understand? All right, and Mr. Platten, you believe your client to be competent to enter into this agreement? All right. All right, Mr. Watson, I see that the plea agreement in your case is that you will plead true to all counts contained in the motion to adjudicate. Today, if the court follows the agreement, your guilt will be adjudicated. That means you will be convicted of that offense. Your community supervision will be revoked. You will be assessed punishment of 288 days in the county jail under section 1244A. You will receive credit for 282 days. You will serve the remaining 6 days that you owe on the dates of February 3rd to February 5th, and then again, February 10th to February 12th of this year. And in addition, you will be responsible for paying your remaining fines and reimbursement fees. Is that your understanding of the plea agreement? And that's what you're asking the court to approve today? All right. All right, then, Mr. Watson, I'm going to ask you at this time, how do you plead to the counts alleged in the motion to adjudicate? Are those counts true or not true? And are you telling me that those counts are true because, in fact, what is alleged is true? You're not just saying that to get a plea agreement? All right, court will accept the defendant's plea of true. Mr. Platten, any objection to the admission of the defendant's waiver of rights and plea of true? All right, that's submitted as state's evidence, and the court will take judicial notice of the defendant's judicial confession. Anything further from the state?
No, Your Honor.
Anything further from the defense? All right. All right, based on the evidence presented and the defendant's judicial confession, the court finds that Mr. Landon J. Watson has violated the terms of his community supervision. Court will follow the plea agreement reached between the defendant and the state. Court hereby adjudicates guilt for abandoning or endangering a child, a state jail felony offense. Court will assess punishment under section 1244A of the Texas Penal Code at 282 days confinement in the county jail. Mr. Watson will be issued credit for 282 days and will serve the balance of his sentence on the dates as indicated by the court and listed in State's Exhibit A. Court also orders him to pay the balance of his financial obligations. When you go to the jail, Mr. Watson, to serve your sentence, it's going to be very important that you bring with you a photo ID so that they can make sure that you are the person that's supposed to be there. If you show up without it, I would recommend you also take a copy of your judgment and your order. All right. If you show up without those things, there's a possibility that the jail would reject you. All right. And that doesn't mean that you don't get to not serve it. It just means that they call me and they say, Landon didn't do what he was supposed to do. Okay. So make sure you take those things. All right, Mr. Watson, you're hereby remanded to the custody of the Van Zandt County Sheriff so we can carry out the terms and conditions of the sentence. I'm going to have you be fingerprinted with Deputy Everett here, and then make sure that you get copies today. We'll assist you in getting copies of that before you leave. Okay. So whatever days y'all have agreed there, listed on the exhibit. Yeah, it'll say date and time. Come on up, Mr. Watson, right here. Yes, thank you, Mr. Platten.
Right.